Te Ururoa Flavell.
Tēnā koe, Mr Speaker. Kia ora tātou. Ki te minita mō ngā taketai au to the Minister for the Environment. Will she continue to protect the concept of cultural impact assessments as a key tenet of the Resource Management Act 1991? And does she agree with David Taipari, Chair of the Māori Statutory Board for Auckland City, that, like built heritage, it was important to protect archaeological sites or sites of significance to mana whenua?
Mr Speaker.
Honourable Amy Adams.
Mr Speaker, I do agree that particular sites of significance to mana whenua are a key consideration under the RMA. In respect to the second part of the question, I note that cultural impact assessments are not a mechanism referred to in the RMA. However, I am aware that its use has evolved as a tool used by decision makers to give effect to obligations under the Act, in particular under Sections 6E and G and 7A. I can confirm that it has always been our intention to maintain and in some case enhance these provisions in our reforms.
Supplementary.
Supplementary question, Te Ururoa Flavell.
I ask the Minister what she will do to encourage and support the inclusion of technical reports focused on cultural impact assessments into the assessment of environmental effects required under the RMA to ensure that a comprehensive and holistic view of all effects are understood and addressed to achieve the purpose and principles of the Act and to protect archaeological sites or sites of significance to mana whenua.
Honourable Amy Adams.
Mr Speaker, well, of course there is already obligation within Schedule 4 which sets out the requirements of the environmental effects provision that specifically require all applicants to consider all of the effects of their proposal, including on historical and cultural impacts, and work through how they must do that. It is very difficult within the structure of an Act like the RMA to specify exactly how that works in each case because, of course, of the myriad of situations that can arise. But I can certainly assure the member that will continue to be supported under both the current arrangements, and there will be considerable support to councils as to how they give effect to that in practice under the proposed reforms.
Supplementary.
Supplementary question, Te Ururoa Flavell.
How will the Minister encourage local government to co-create with mana whenua systems and procedures to engage effectively with tangata whenua, therefore reducing compliance costs for the applicant without sacrificing the fundamental role that mana whenua have in protecting sites of social, historical and cultural significance?
Honourable Amy Adams.
Mr Speaker, that is a critical part of what the reforms are trying to do, which is to ensure that those interests are involved far earlier on in the planning process. And one of the failings, in my view, to date is that there hasn't been an adequate and effective engagement with iwi and with stakeholders up front in the planning process. So under the reforms, there is the proposal to have an iwi participation agreement right at the outset of all planning, so that council and all of the iwi groups in that area can work together as to how they will integrate all of those issues into the plan frameworks, so that applicants know exactly what they need to do in each situation and what work is required of them in each particular case.
Supplementary question, Right Honourable Winston Peters.
With regard to the unelected Māori Statutory Board for the Auckland Council, why have 19 iwi been given unbridled power to claim rights to any piece of land in cultural impact assessments, some so special the reasons may not be disclosed, and yet charge applicants iwi by iwi thousands of dollars for these approvals?
Honourable Amy Adams.
Mr Speaker, well, the bulk of that question really is outside my responsibility as Minister, but what I can say to the member is that my understanding of what the Council has proposed in their plan, and this is a matter for the Council, its plan and its community to work through, what that's proposed is that the Council is requiring consultation, not approval rights. They're not giving rights of veto, they're not requiring approvals, they are requiring consultation in certain situations. Now, how that works, how far the net is thrown, and whether that's appropriate is a matter that's being worked through right now.
Question number 5, Jacinda Ardern.
Thank you, Mr Speaker. My question is to the Minister for Social